All right, Mr. Chair, the live stream is ready, so whenever you want, you can start.
Okay, good afternoon. Due to COVID-19, Committee of Adjustment public hearings are being conducted virtually by electronic means through WebEx Webinar, an online digital platform, and streamed on the Toronto City Planning YouTube channel. Participants who have registered in advance will be able to make their presentations to the committee using WebEx Webinar, which is moderated by city staff. Anyone wishing to view the hearing may watch on YouTube. Participants who have registered in advance will be connecting with their computer, tablet, smartphone, or telephone and have the option of participating via video or audio only. All participants will automatically be muted on entry. And when your item is called, each participant will be unmuted by the moderator, one person at a time. We also ask that you mute your devices until you are called on to speak. Those participating by video appearance will be temporarily upgraded to panelist when your item is being held. During this time, your camera will be enabled. You will only be visible during your 5-minute allotted speaking time, and at all other times, your video will be disabled and you will be reinstated as an attendee. Committee of Adjustment staff will share presentations submitted in accordance with the written submission deadline. Members of the public and applicants are not allowed to use share screen or any other panelist controls during a video appearance. The host will remove you from the panelist role if you fail to respect this instruction. Land acknowledgement. We acknowledge that the land we are meeting on is traditional territory of many nations, including the Mississaugas of the Credit, the Anishinaabe, the Chippewa, the Haudenosaunee, and the Wendat peoples, and is now home to many diverse First Nations, Inuit, and Métis peoples. We also acknowledge that Toronto is covered by Treaty 13 with the Mississaugas of the Credit. In accordance with sections 45 and 53 of the Planning Act 1990 as amended, this meeting of the Committee of Adjustment of the City of Toronto is called to order. The Committee of Adjustment considers applications for variances from the provisions of the zoning that apply to the property, permissions to extend or alter lawful non-conforming uses, and consents to sever properties to create new lots. Anyone in attendance today who wants to receive a copy of the decision of the committee on an application must submit a written request for a decision by email. Please ensure that you include your name, address, and email address because the Committee of Adjustment and the Toronto Local Appeal Body, in the event of an appeal, will be sending notifications and appeal updates by email. If you do not agree with the decision of the committee rendered here today, you may be able to appeal the decision to the Toronto Local Appeal Body or in some limited circumstances to the Ontario Land Tribunal. However, the provincial government has recently amended the Planning Act and generally removed rights of appeal of third parties to appeal Committee of Adjustment decisions. As of November 28, 2022, only the applicant, the Minister of Municipal Affairs and Housing, specified persons and public bodies as those as defined in the Planning Act, are permitted to appeal decisions of the Committee of Adjustment. Appeal instructions are set out at the bottom of the decision of the committee. The hearing procedure is as follows. I will call each item in the order listed in the agenda, starting with item 17, and making your submissions where an application is uncontested. The agent or applicant may proceed with a presentation if they desire. When the committee does not require a presentation, applicants are to advise the chair should they wish to address the committee, and the committee may ask questions and then take the matter into the committee for a decision. Each speaker, including either the applicant or agent, will be given a maximum of 5 minutes to address the committee, and the clock is in the room and we will comment when you're approaching or bypass the 5-minute mark and ask you to wrap up. When addressing the committee, please remember to start off by stating your name and address for the record, and please remember to confine your remarks to the matters outlined in the application. The applicant or agent goes first and makes their presentation to the committee on the application. Please note that the committee may not entertain revisions made to proposals at the hearing today. The committee may decide to defer the application if being substantially revised in order to ensure that the revised application is accurate and that all those entitled to notice of the application have been informed of the changes. Then individuals either in support or opposed to the application with concerns will be invited to speak. Committee members may ask questions of each speaker after they finish their presentation, And when all other speakers have finished, the applicant or their agent will have an opportunity to rebut only those issues and answer those questions raised by the speakers. That will then mark the end of the discussion, and the matter is then taken into committee for a decision. Do any of the members or staff have any conflicts of interest to declare on the matters before us this afternoon? Okay, none to declare. Deferral requests. I believe we have on this afternoon's agenda. Okay. Item 17 and item 23 are on the list as requiring deferral. So we'll do those first and clear them from the agenda. So the first item we're going to call is item 17, 1306 to 1310, the Queensway. We have one speaker, Tom Jankos, and it's an application to permit a parking deficiency for the 3 proposed buildings with 2 variances. And we have, I believe that's on the list as D3. So let's get Tom Jankos on the line.
Good afternoon, committee members. It's Tom Jankos here.
Good afternoon, sir. So we have, I'm just pulling up our consolidated planning memo. We have a request for reason number 3, which is in order for staff to consult with other city divisions and or external agencies to obtain information, clarity on the proposed minor variance and consent application. So I believe there was a talk about a deferral May 4th pending a parking study, but it looks like in the materials you now have a parking study, or?
Yes, Mr. Chair. So we're in a bit of a unique situation. So again, it's Tom Jankos, Senior Vice President at KIngsWAY Capital. I'm an urban planner who studied both at Ryerson and the University of Central England. I live in Etobicoke. We do quite a bit of work in Etobicoke. And we're in a unique situation here, and I'll just walk you through it very briefly. This site
is it related to the merits or the issue of whether this should be deferred or not?
Is related to the deferral.
Okay.
And I'll be as brief as possible.
Yeah.
What we are doing here is we're seeking 2 parking variances, and the variances just simply allow us to align with the newly imposed city zoning bylaw. That's all we're doing. So nothing really changes if we get a parking study. We are actually submitting these variances to align with this new City of Toronto parking bylaw that went through public consultation, a series of studies endorsed by Planning and Housing Committee at Toronto and approved by City Council. So I don't believe that an additional parking study would do us any good, and we'd like to proceed if possible.
Okay, because you're taking advantage of the new city bylaw that does not require any parking.
Correct, sir.
You're updating a previously approved application where you were doing so. You're saying, and you do have a parking study that's dated March before their request in May, but you're saying it's redundant, it's not met because you're proceeding on this new bylaw that doesn't require a parking study, it just doesn't require parking. I guess you are providing 44 resident visitor parking spaces.
Correct, sir. And this is the second time we've done a similar variance in the City of Toronto to align a site that was previously approved with the new City of Toronto parking bylaw.
Okay.
And that site was approved previously downtown.
Okay, so having not read completely this planning report, is it basically they don't take into consideration the fact of the new bylaw?
The comments from transportation, the comments from planning relate to the comments from transportation. And what transportation says is we want a parking study. And they also acknowledge in their letter that what we are requesting in terms of the variances actually align with the city bylaw. So that bylaw endorsed by council went through various iterations, years of study, public consultation. Again, for us to provide another study is almost a redundant exercise. The city went through its own studies.
Yeah, I agree that there's no requirements, so why do you have to produce a study? However, or that question for staff then, and for you, sir, as a registered planner. So is the variance correct, or we don't really have a variance because of the new bylaw?
We have 2 technical variances. We have a site-specific bylaw. So we are required to vary that site-specific bylaw so that it aligns with the new City of Toronto parking bylaw.
Right. So when you got your site specific, it was when the city had specific parking ratio requirements.
Correct,
So
sir.
you have to get that off of your bylaw, not the city bylaw. It's my
Correct, sir.
Okay, let's see if you're the only speaker. So let's see if any of the members have any questions for you, or if they're ready, given your explanation to, I guess you've already dealt with the merits in the discussion anyway, but see if they have any other discussions or if there's anything else you'd like to add once the committee members make a decision to hear this matter. So let's do that in two-step. You'll have an opportunity to make further submissions should you wish. So members, on the issue, firstly, of the deferral by request by transportation, the explanation by Mr. Jankos, either not have the deferral or to proceed.
Yeah, if I can, I'm trying to think if we decided to go along with the variances requested, would one of the conditions be satisfying transportation, which would be this parking study?
Well,
or in the alternative,
would be
if
not
we give approval without that condition, could the city then appeal it? So
okay.
I would think a better scenario would be to seek a deferral to try and work something out with transportation so that we're given clear direction on how we should be proceeding on.
You're opposed to the applicant's request to not defer this matter.
Yeah, I think it should be deferred.
And perhaps we can have a discussion and someone can make a motion on whether this matter should be deferred or not.
If I could just comment too, I actually agree with Mr. Palmer. I think it should be deferred. We're not talking about 20 parking spaces here. We're talking about 600, and there's still a deficiency in the visitor parking as well. It's a lot. So I am in support of a deferral.
Okay, so you'll take that as a motion because what I'm saying is there is a requirement. It's under a site-specific bylaw that is made, and time may be of the essence for or not. We'll let Mr. Giancos comment about that. But okay, so let's deal with the deferral issue first. So fine, you've made a motion to not to have this matter deferred, notwithstanding.
I could second Mr. Palmer's motion to defer, but
I think in fairness, we should let Mr. Giancos just respond on because we didn't. Would there be any, what would be the, I'm looking for a word, downfall or the prejudice to your client or you of having this matter deferred, if any? Just because you are concerned that notwithstanding, you've explained that there's no longer any parking requirement, but there is in your site-specific zoning bylaw, and that's why you're here. They're concerned because of the it's not like 1 or 2 parking spots. It's a big number of 630. And I assume there's also no visitor parking requirement under the new bylaw, but I just want to give you a chance to comment on any potential prejudice before the members vote.
Sure, thank you for that opportunity, Mr. Chair. We are providing visitor parking. We're providing 44 visitor parking stalls, which is in line with the city's new bylaw. If the members vote for a deferral, I am in your hands. But I don't think that will resolve or change the nature of the variances we are requesting. And I'm also, it's a bit of a unique situation to be in front of committee asking to vary a site-specific bylaw so that we conform to a citywide bylaw. And transportation staff takes the position that they are going to ignore that citywide bylaw. They're going to ignore all of the public consultation, all of the reports that had council approving that bylaw and require from us an additional study. And when I say that, I'll give a bit of background. There's probably been about 30 sites in the past year throughout the city of Toronto, in Scarborough, North York, and downtown that have all been approved with very similar or identical parking ratios. There is the Cloverdale Mall site that is currently in the redevelopment process. And we understand that through discussions with transportation staff and planning staff, they have agreed to provide this, to allow the same type of ratio that we are asking for. So again, I am in your hands for a deferral, but I would likely be in front of this committee asking for the same thing. And again, all I am simply
Sure. I know you're going to be asking for the same thing. What the members are saying, because the members, they want clarification from transportation, given they've written a memo that has no mention that the fact that the city now has gotten rid of that requirement, etc. So that's what they're looking for. I know you're going to come back with the same thing. The reason I wanted to give you a chance to discuss the prejudice of having it delayed by 2 weeks or a month or whatever staff can get you back on, because I never thought that the committee members would think that this should be deferred, giving you an explanation. But given that the learned members have made a motion now, so we're going to vote on that motion, okay? But
Okay,
I know come back with the same thing. That's not with it, what their concern was and why they wanted the deferral, because to make changes, they wanted to just get further direction from transportation. And that's the reason. So we have a motion. We have a seconder for that motion. We're now going to vote on that motion. All in favor of the motion to defer? Okay. Opposed? Me. So the motion matter is deferred. We'll see you back here again, sir. And I guess transportation will have an opportunity to clarify, and you can get back together with staff to see when the earliest date you can get back on. Okay. Thanks so much. The item has been deferred. Okay, item number 18 is also parking, but on a much smaller scale.
Sorry, we have item 23, which is a deferral.
Oh, right. Sorry. Okay, right. I was going back to, because we're at 17. Yes, item number 23 then. Thank you, Madam Secretary Treasurer. Is, get the right page there. Okay, 24 WATERBEACH Crescent. Okay, and this is on the memo for, again, D6. It's an additional materials. We have a deferral memo from the agent. This was an application, just to put on the record, to construct a new detached dwelling with an attached garage, and there are 8 variances. So the speaker on this matter is...
Mr. Chair, the speaker is Ravi Rami, and they've asked to be on camera. So I'm going to go ahead and make them a panelist now. Ravi, you're now a panelist, so you can now activate your mic, your camera by clicking the start camera button, and you are unmuted.
And sir, we have also a neighbor, Adam from 34 WATERBEACH on the phone, or
Mr.
not?
Chair, I can confirm that the area resident from 34 WATERBEACH Crescent is present on the call at this time.
Okay, so we'll have to check in with them as well. As a courtesy. So, okay, so firstly, let's hear from Ravi Rami.
Hi, we are requesting for the deferral because
Sir, can you please state your name and address formally for the record? Thank you.
Okay. Hi, my name is Ravi Rami and I'm owner of the 24 WATERBEACH Crescent. Okay, and we are requesting for the deferral. We received the comments from the Jamila, and we are trying to understand those one, and we are trying to make the changes based on her comment. And we would like to present the new plan depending on her comment.
So you've received a negative planning report April 27th, and as such, you want to defer in order to make changes and speak with planning.
Yes,
we're correct. Okay.
Yes.
Thank you. Okay, so let's just any questions for Mr. Rami, panel members? And if not, let's just touch base with the neighbor, Tim Amaro, at 34 down the street. Mr. Amaro?
Yeah,
Welcome.
that's me. Thank you
Welcome.
so much. Thank you for having me.
Okay.
There's sorry, go ahead.
As you may have heard, we're not going to be hearing the application on the merits today, because the applicant has requested a deferral to make changes because they received the report from the planning department that the planning department was advising the committee to refuse the application. So he's exercising his right to defer. So we're not going to hear about on the merits. If you have any concerns, we're not going to hear them today. We're going to hear them another date when he comes back, and the application will likely be somewhat different.
Okay. Will you guys be resubmitting for the next meeting?
Yeah, there'll be a recirculation of the notice. If you receive the notice of this meeting, you'll receive a notice of the meeting when it's brought back on.
Oh, okay. All right. How long roughly would this take?
It's just up to see how long the applicant does what he wants to do and discuss with who has. It's completely in the applicant's hands, sir.
Oh, I see. Okay. All right. That's super then. So I'm done for today with this, right?
That's right. Unless you like to watch and see, there's another dozen applications if you're interested in watching. Other than that, this one's done.
I'd like to, but
Other things
I got
to do.
a dozen other things to do.
Awesome. Get some sunshine.
Okay.
Okay, sir. Thank you.
Thank you so much.
Okay, members. So applicant is requested to defer for the given his negative planning report to make changes. Can I have a motion, please?
Move to defer this application to allow conversations to continue with planning staff.
Thank you, Ms. McCluskey, seconder for that. Ms. Alderson, thank you. All in favor? Okay, the matter is deferred. I thought we had one other request, but I think it was rescinded from transportation on item 27. So I think that's all we have. So we can go back to the top of the agenda for this afternoon. And start. The first item is item number 1820 CLISSOLD Road. Okay, hold on a second. Okay, yes, this is another, this gets minimized. This is an application to permit a temporary asphalt driveway in the front yard for a period of 3 years. There are 4 variances. We have a memo from, it's not on letterhead, or it's from Reno Frazio at the Transportation Standards Officer for Etobicoke wards 2, 3, and 5, and he has no objection. And yeah, we have the transportation memo regarding the 3-year approval. And okay, and we have a Metrolinx advisory, and I believe we have support. Speaker on this application is back to 18.
Mr. Chair, the speaker is Scott Jackson.
Okay, Scott Jackson, correct. Only the one speaker. Welcome, Mr. Jackson.
Hi, thanks for having me.
Okay, you have the letter from the Transportation Standards Officer, right-of-way permits and enforcement, I assume. Just if you can give us just a brief presentation of this temporary period. I have your site images here, which you provided. Perhaps we can get those screen.
Great. Well, again, thanks for having me. I'm representing the owner of 20 CLISSOLD Road. I should also add, I also work for the developer behind the retirement home residence to be built directly north of 20 CLISSOLD at 3411 and 3429 Bloor Street.
Okay.
So as developer, it's our intention to start construction later this summer. And we basically want to use the laneway for construction staging and construction trucks in and out. That laneway will allow us to avoid staging in the neighborhood and trucks coming into the neighborhood. So we think it's a win for everyone if we could use that laneway. The parking pad for 20 CLISSOLD is located off of that laneway, hence the reason why we want to move it to her front yard. So this is for a period of 3 years, after which time we'll reinstate the front yard back to the original condition, if not better. And again, we feel like it's a minor request. It just doesn't comply with the current bylaw. And yeah, I'm happy to take any questions.
And there's certainly public good because you keep some construction marshalling and off of Bloor Street. And
exactly, absolutely.
I like that this neighbor at 20 CLISSOLD is being accommodating. I don't know if there's any compensation, whatever, to allow this to occur because it's obviously for the public good.
Right. We've been working with her all along, not just on this issue, but highbacks and encroachment and other things. So we have a good relationship with her.
Wonderful. Okay, members, any questions for the speaker, or is someone ready to make a motion?
Yeah, Palmer, I've got a question. Sir, are you aware of Section 39 of the Planning Act, which is the temporary use bylaw provision?
I'm not all that familiar with it. No, I apologize.
Okay, this specific request you're making is in that section of the Planning Act. It allows for a temporary use that's not normally allowed for a period up to 3 years.
Okay.
So you're not aware of that. I would just argue that this is not the right form for this request, that that section of the Planning Act is the right forum, which is a request to council, I believe.
When I applied to the city for this, it was instructed by staff to go through this channel. So I was following the direction of staff at the time when we applied for the permit.
Okay, no, that's fine. Yeah, I would just start, because then you're gonna, if you need more than 3 years, you're gonna have to come back here in 3 years before us again and ask for an extension again. So I'm just saying there's a section in the Planning Act for this request.
Neil, I wish I had spoken to you 2 months ago.
Yeah, I actually did a report on this for the city of Pickering 33 years ago.
Yeah.
One of my first jobs. So anyway.
Good to know. And I should say that the 3 years is an outside date. It's probably going to be more like 24 months.
Okay. All right. Thank you.
Okay. Any other questions for the agent? If not, is someone ready to weigh in with a motion? Mr. Taylor? You went off screen.
Push the wrong button.
Okay.
Now I got to push the other button.
Or you can just speak without us seeing you. We know what you look like. Okay, there we have you back.
So, yeah, I take Mr. Palmer's point, but I'm thinking if the applicant has been steered in this direction by city staff, we should try and accommodate him. I see this as a reasonable accommodation for a short term. So satisfied that it meets the 4 tests, and I move approval without conditions.
Thank you, sir. Motion by Mr. Taylor. Do you have a seconder for that motion?
A transportation services is asking for a condition, I believe. They're asking that for the term to be included.
For 3 years.
Yeah.
That's what Mr. Taylor's motion is to approve it for a period of 3 years.
Yeah, I guess that was my thinking. I read that and thought, well, that's unnecessary because that's exactly what we're approving.
Yeah.
It's usually better to include the term as a condition.
Well, you can do it both ways, I guess, because what's before us is an application for 3 years. We're approving the application. It's almost redundant, but if staff would prefer that, I don't see any harm.
I'm quite content to modify my motion to satisfy that concern. So I'm just pulling up the purpose again, or the. Okay, I'm going to need some help because I guess I'm thick, but I'm seeing we're approving this for a period of 3 years. I don't know how we would make that a condition. Because we're permitting a temporary asphalt driveway in the front yard for a period of 3 years.
So sometimes people don't notice or don't pay attention to the purpose. They just look at the variances themselves because the purpose is not necessarily a condition. So to ensure that the variances that are considered expire, that is why you would add the condition.
Okay, so I would say subject to the permission expiring after 3 years.
Yes, thank you.
Okay, did we have a seconder yet for that? I can't remember. I think Mishi or Laura Anderson. Thank you. Laura Alderson, second. All in favor? Opposed? You're in favor, Mr. Palmer? Thank you. It's unanimous. Okay, you have your approval. Thank you, sir. Good luck with your project. Okay, next application is item 19. 24 Lorraine Gardens. We have on this application, it's for a new detached dwelling with an attached garage and an ancillary building in the rear yard. We have the revised page for the agenda highlighted to show changes. So there were 5 variances. One of them has been revised, the lot coverage. We have an applicant's email with the updated plans. Transportation has no concerns. Oh yeah, they advised that the zoning examiner had made a calculation error and it's now been updated. We have a forestry memo. We have urban forestry looking for condition number 2, and in the additional materials we have renderings. And the speaker on this application is Stephen Key. He is the only speaker.
Good afternoon, Mr. Chair and fellow committee members. My name is Stephen Chi, a senior planner from Design Plan Services.
Welcome, sir.
Thank you, sir.
So you made these revisions to request a community planning for the coverage, or what happened here? Why do we have a revised page?
Yeah, so basically, the zoning examiner made an error when he was calculating the coverage. So the variance has been revised from 42.2% to 39%.
Okay. Okay. Anything else you'd like to advise the members of before I see if they have any questions?
Sure. So I just want to know that we have consulted extensively with planning staff, particularly regarding the proposed lot coverage, and staff are supportive of the application, and they have not provided any comments to the committee. Again, transportation services provided comments, and they have no concerns. We have reviewed the urban forestry memo, both the report and consolidated memo, and we have no issues with the recommended standard condition. Further to the advisory comments from urban forestry, the tree in question is actually related to the proposed pole and not related to any of the variances. However, we have confirmed with the owners, it is also their intention and interest to protect that tree, and therefore they are willing to redesign and relocate the pole so that the tree can be preserved. However, that will be dealt through future pole permit or tree permit.
Okay,
and I'm happy to answer any questions. Thank you.
Okay, thank you, Mr. Key. Any questions for Mr. Key, or is someone ready for a motion? Mr. Taylor?
Yes, Mr. Chair, I'm satisfied that the variances requested meet the 4 tests under the Planning Act, and I move approval subject to urban forestry condition number 2.
Thank you. Seconder for that motion? Ms. McCluskey, thank you. All in favor? You have unanimous approval. Thank you, sir. We'll see you again. Okay, next application is item number 2021 Bell Royal Court. It's an application to construct a detached dwelling with an attached garage. There are 4 variances. We have supporting materials. We have urban forestry looking to deny variance 2. We have urban forestry looking, for the refusal. And this, in the additional materials, we have 6 Bell Royal in support. And I think we had that twice. Okay, and that's basically all we have on that. The speaker on this application is Tay Ruck.
Afternoon, committee and members. My name is Tay Rook. I'm the planner for the owner of the property at 21 Bell Royal Court.
Okay, welcome. I think we need a full presentation for this. Would you like to, anything you'd like to advise to summarize what we're doing, what you're seeing here?
Sure, sir. There was presentation slides that I had provided to the committee. I believe it's on file. In addition to that, just before I start, there are 2 letters of support that were submitted. I know on the system it shows 6 Bell Royal Court twice, but the second one should be 19 Bell Royal Court. It was submitted a couple of days ago. For some reason, it just hasn't been updated to the system. I'm sure the committee members have it. It was sent out to Adam Wills. Just wanted to let you know that.
But that's next door too, so that's 19, because I don't have that.
It's 19.
We have 6. Okay.
Okay.
So we have that somewhere and we just didn't get it, or
possibly. So the map before you are the properties that have been highlighted in green are those properties that have a GFA that is 165 square meters plus and above 25%. And you'll see that the subject site has been outlined in red in the dashed line. And within that court, Belle Royal Court, there are 5 properties within that area that have a similar GFA above the 25%. They're plus 29% or 30% in certain circumstances. And as it relates to the side yard setback, if you go to the site plan that was on the next slide, it relates to the aggregate side yard setbacks that's required for both sides. But you'll note that on either side where it's been highlighted or circled in red, it's above the minimum requirement of 2 meters. And if you look at previously on the property data map or the area context map, there's properties that have been indicated with triangles. Those are properties that have reduced side yard setback, either in terms of the minimum requirement or the aggregate requirement as well. With respect to the, there's a variance related to the height of the rear deck. And that's because if you go to the next slide, there's a grade difference that occurs along the back of the property and front to back as well. And you'll note that that blue area indicates the slope that occurs along the width of the rear of the lot line. In addition, you'll note that there's a dashed line at the bottom of the blue area that represents the actual established grade where this measurement is being measured from. And that is why we have this 2.27 meter measurement. In actuality, from physical grade and from actual physical ground, it'll be less than the bylaw requirements, and it would comply with the proposed in terms of the bylaw. Finally, in terms of the lot coverage variance that's being sought, we're seeking 33.9%, whereas 33% is permitted. And I would submit to committee that in terms of impact and in terms of whether or not it would be noticeable, it'd be somewhat indiscernible from a streetscape perspective and also from a impact perspective as well. Lastly, there was comments from Urban Forestry that indicated that this application be refused in terms of variance for number 2, which is the GFA variance. And that all relates to the tree that's located. And this tree is a 9-centimeter tree in terms of diameter. And if you look at the site plan, it's located just west of the proposed new driveway. And what I would submit to you that if you look in the site plan, there's an existing driveway that's located on the left side of the plan, which is a much larger asphalt area. And the proposed driveway is a much smaller area in terms of asphalt. So in addition, in reality, you'd be greening additional green space in the front yard. We did have a conversation with Forestry Department after we saw the comments, and we saw the comments on May 5th. So we had a conversation with them last week, and they indicated that they agreed that there are options available for that small deciduous tree at 9 centimeters in terms of diameter. And you'll note that there's plenty of room to replant or provide additional plantings in the front yard, or to relocate or to provide protective measures to save that tree if need be. So there are options available to Urban Forestry and to our, and in agreement with our landscape architect and the arborist. You'll also note that TRCA provided comments and they had no concerns, and planning had no issues as well.
Okay, thank you for that presentation, sir. So I see planning hasn't commented. I'm just wondering if there's an appropriate explanation about the side yards. It is wider. It's only juts out in a few spots. Whether it would be prudent to, tie any approval to, the site plan dealing with the side yards. That was just my only thought. There is another speaker on this? Or no, is there another speaker on this?
Mr. Chair, there is not another speaker on this.
Okay, thank you. So members, any questions for the agent? Okay.
Mr. Chair, not a question, but a comment. In addition to this is an Urban Forestry comment, in addition to their comprehensive chart, which just has the denial indicated, we did get a freestanding memo from Urban Forestry calling for condition 2 in the event that we wanted to proceed. As stated
Correct.
May 1st. TPPR?
Yeah.
Yeah.
Sir, do you see that? So you're okay with urban forestry condition 2 being, we're only talking about private trees, not public trees, correct?
We're talking, correct. So we have no issues with the conditions of approval if the committee decides to approve it. And also back to your thought of tying it to the site plan, we have no issues with that either.
Okay. Okay, so you're fine with condition 2. Okay, any other questions? And if no other questions, is someone ready for a motion? Mr. Taylor?
Yes, Mr. Chair, I'm satisfied that the requested variances meet the 4 tests under the Planning Act. And I move approval subject to urban forestry condition 2. And also a condition that the construction will be in accordance with the site plans that have been submitted to the city.
With respect to the side yards, you usually have to specify what you're concerned with when you do that.
Yes, okay, yes, with respect to the side yards.
Okay. Thank you very much. Is there a seconder for Mr. Taylor's motion? Ms. Alderson, thank you. All in favor? Okay, you have unanimous approval. Thank you. We'll see you again. Have a good afternoon. Okay, our next application is item number 21. That is, okay, 51 BRAYWIN Drive. It's a 1-story rear addition, a partial 2nd-story addition, a new front porch and a rear deck. Two variances. All we have is an arborist report, and we have urban forestry request for condition number 2. And the agent speaking on behalf of the owner on this application is Joe Dome. Welcome, Mr. Dome.
Yes, my name is Joe Dome, 133 Torresdale Avenue, agent for the owners.
Okay, looks like very straightforward. You have a couple of variances, and if you'd like to walk the members through anything, otherwise, well, we don't have anything on urban forestry request.
Yes, so just to highlight a couple of points, that the requested FSI of 0.53 is just a small increase over the as of right bylaw of 0.45 and is below the massing of a number of other dwellings in the immediate area, the most recent of which, 24 BRAYWIN, was approved earlier this year with an FSI of 0.65. The adjacent neighbor at 49 BRAYWIN also has a substantial 2-story dwelling, which extends to a similar length as the proposal today, which is within the bylaw at 14.56 meters. And the front yard setback variance of 8.24 meters, this is an existing condition, only applying to the existing garage portion of the dwelling, whereas the remainder of the front main wall on both the 1st and 2nd stories, including the proposed addition, is set further back and meets the bylaw. And overall, the impact is mitigated by the fact that the proposal meets the bylaw for lot coverage, overall height, main wall height, length, and both side yard setbacks. And finally, the owner has spoken to both adjacent neighbors at 49 and 53 BRAYWIN, and they have no concerns, and planning has no concerns. And we feel the application is quite reasonable and minor in nature, and I'd be happy to answer any further questions.
Okay, thank you, Mr. Dome. Any questions for Mr. Dome, or someone ready for a motion?
Oh, just a comment. I thank the agent for the applicant for bringing forward the comparables. Very nice. Thank you.
Okay. Is that tie into you making a motion?
Sure, why not? I believe this application meets the 4 tests under the Planning Act. Move for approval subject to condition urban forestry condition number 2.
Thank you. Seconder for Ms. Alderson motion, Mr. Palmer, thank you. All in favor? Unanimous approval.
Thank you very much.
Okay, we'll see you again, Mr. Dome. Be well.
Thank you, you too.
Okay, item number 22 is 21 16th Street. It's an application for a new detached dwelling with an attached garage. And we have a revised sheet highlighted to show changes. There were 5 variances. There are now 4. One of those has been reduced, the FSI, the length has been eliminated. And all we have on this application is, we have the revised plans, obviously. When we have that, we have supporting material, the Lime Branch Neighborhood Association guidelines. We have arborist report, transportation, and opposition from number 19, transportation, no objection. So the speaker on this application is Jonathan Benkowski, no other speakers.
Good afternoon, committee.
Welcome back.
Thank you, sir.
Okay, so you've revised your plans, you've eliminated a variance and reduced another one.
Correct, Mr. Chair. Yes, after speaking with planning, I came into this file a little bit late. I actually recommended that same change happen. As did the planning department, that change was done. We've eliminated the maximum length. Sorry, the proposed length. In turn, the FSI has been reduced. In terms of, I mean, I'm not sure if you'd like a quick presentation or if you have some questions.
One we just see is pretty straightforward once the changes have been removed. So let's see if members have any questions for you. And you're okay with urban forestry 1 and 2 that's been requested?
I am, sir.
Okay, I'm just looking. I don't know if there's anything in the next door neighbor's letter that needs, or that justifies a response.
It largely dealt with the length.
Yeah. Okay. Okay. Any other questions? Any questions for Mr. Benkowski, or someone ready for a motion?
No, I do think that letter was written before the revisions were made.
Through you, Mr. Chair. Absolutely, Ms. Alderson.
Okay.
Okay. Anyone ready to make a motion, or any further questions?
I'm happy to make a motion if no one has any questions. I move for approval of the variances. I believe they meet the 4 tests under the Planning Act. Minor in nature, subject to urban forestry conditions number 1 and number 2.
Thank you. Seconder for that. Ms. McCluskey, thank you. All in favor? Unanimous approval. Thank you, Mr. Benkowski. We'll see you again. Be well. Okay, 23 was deferred, so we can jump over to item number 24, which is 18 Taylorwood Drive. It's an application to construct a new dwelling in an attached garage, and there are 6 variants. Well, keep going. 8 variances. We have, where are my notes? We have a previous decision from February 2020. My question is, was that built? We have supporting material and presentation material. Basically, planning is looking for 2 conditions of approval. In event of approval, they like the bird dark sky compliant window lights and bird friendly window treatments. Transportation is okay. TRC has no objection, and number 14 is in support. And in the additional materials, we have a revised notice. There were 8 variances. Number 3 was revised. And the speaker is Peter Giordano. Welcome, sir.
Thank you, Mr. Chair.
Yep.
Peter Giordano, David Small Designs, 1405 Cornwall Road in Oakville.
Okay, so we have, maybe we'll put your supporting material up on the board. First package, this is your renderings and your statistics, and if there's anything. So is there anything you'd like to walk through? I guess you're okay with, I get the planning conditions and the urban forestry condition. No, there is no urban forestry condition, sorry. So my question to you is also, was this built, they got approval in 2020? Was it wasn't built, I take it?
2020 was a different client. It wasn't our client. With different owner, different application entirely.
Okay, so that's redundant, was never built.
Correct.
Okay. Committee members, would you like Mr. Giordano to walk through anything, or is someone ready to just ask some questions and make a weigh in with a motion? I can't see everyone. So. Mr. Taylor?
Yes, Mr. Chair, I'm satisfied that the application meets the 4 tests of the Planning Act, and I move approval subject to the Community Planning Department condition.
Okay, thank you. A seconder for that?
And that approval relates to the revised notice.
Sorry
Yeah.
for the interruption. I didn't get my hand up quickly enough. I know transportation is okay with the variances requested, but because of the amount of asphalt that we're looking at in this development, I'm wondering if we as a committee can request permeable pavers be used. Because there are 2 variances that have to do with asphalt. So I'm wondering if that's probably that's a question of staff. I'm wondering if that is something that the committee can request.
I mean, it's
Right.
whether the applicant is okay with that. I just see a driveway width.
There's a driveway width, variance 7 and variance 8 both have to do with the amount of asphalt that's actually on the property. And so I'm wondering if
They actually don't have a landscaping variance.
Yeah.
It's just the width of the driveway.
yeah, but it
So they
needs more
comply with,
asphalt.
But there's no landscape variance. So they
yeah,
obviously
they comply with the hard surface versus soft.
Okay.
It's just the actual width to be able to fit the driveway.
So
pretty much.
there's no variance on that. Okay. I
No.
just thought it might be something that we could request. Okay, that's fine. I'm happy to second that motion then without that friendly amendment.
Yeah, on a new build, he may be doing it in any event, but so.
Trying to be environmental, that's all.
Okay, so you seconded the motion without amendment?
I did.
Okay, so all in favor? It's unanimous. You have your approval, Mr. Giordano. Thank you. Okay, our next application then is item number 25. 25 Mabelle Avenue. It's an application to sever the lot into 2 properties to create easements, rights of way, not substandard lots. This is to accommodate this apartment building being proposed. We have a cover letter, supporting material, cover letter from Kagan Shastri, with a copy of an Ontario Land Tribunal decision from November 2021. Planning has conditions of approval. We have the engineering construction services memo, Metrolinx advisory, a TTC memo, landscape plans, and in the additional materials, we have a presentation materials, which we can perhaps get on the board. Planning has advised in an email that they will not be commenting on this application. And as well, in the additional materials, we have an opposition letter from the Tenants Association representing tenants at 25 at the actual building at 25 Mabel. And that's what we have. The speaker on this application is Paul DeMello, and that's the only speaker we have. Welcome, Mr. DeMello.
Thank you. Good afternoon, Mr. Chair, members of the committee. My name is Paul DeMello. I'm counsel for the applicant. I'm a partner with the firm Kagan Shastri DeMello Weiner Park. I'm noticing there is a presentation on screen that is not the subject property. There we go. Those are the variances. As you've noted, Mr. Chair, this is a consent application to sever the property into 2 parcels to allow for the future redevelopment of what will be the severed parcel. The retained parcel has got an existing apartment building on it of 416 units. Some of the comments that in the letters, in particular from Development Services, relate to the parking. Part of the OMB decision, the OLT decision, reduced the parking standard requirements for the entirety of the site. So what my client is doing is reconstructing the existing parking at the existing apartment building. Throughout the redevelopment, which will include a future shared access, which is one of the easements that's created between the existing building and the new building. They're going to be maintaining the existing parking on site. There's going to be a separate access for the parking for the new building. And through that time, they're going to maintain the 290 parking spaces required under the bylaw. That was a letter from the Tenants Association asking that that be included as part of the decision. I can advise that we've also reviewed the conditions that have been proposed by the TTC and Metrolinx and spoken to who will be the future developer of the severed parcel, and they have no objections to any of those conditions being included. Those conditions largely deal with the future redevelopment of the property. And in the planning memo of May 3rd, there are conditions that are requested by planning department with regards to improvements that my clients had undertaken and spoken to during the context of the hearing and the development, which were some internal improvements, a children's playground to be constructed, some improved landscaping. Those are all commitments that my client made during the hearing, and the committee has asked, the planning has asked that they be secured as much as possible through this process. So we worked with them on the drafting of the appropriate conditions, and we're satisfied with the conditions as drafted. And finally, as you will see, it's not only this creation of the 2 parcels of land, but also the easements as between the 2, which will provide for a better operation between the 2 buildings in the future, including an easement for access for future garage storage and access for efficiency between the 2 buildings. Happy to address any questions that the committee may have.
Hey, thank you, Mr. DeMello. Members, any questions for Mr. DeMello, or is someone ready for a motion? And we have, the conditions, and my screen is just frozen, so I can't go to the planning memo, but.
There's a condition from the planning memo. There's a comment from development engineering that they want to just see the legal confirmation with regards to easements. Again, no problem. There is a standard warning condition from MX for future purchasers and a TTC condition, which again, we've reviewed with our clients and reviewed with the future developers on the severed parcel, and no concerns with any of those conditions.
Okay. Mr. Taylor?
Yeah, Mr. Chair, this is with regards to the Tenants Association letter, and I'm just wondering, can maybe staff confirm that the so-called construction parking plan, is that going to be something that's going to be enshrined as required elsewhere? Or to satisfy the association, can we, or may we attach a condition to that effect? Or is it going to happen anyway?
It's difficult to include a condition requested by a neighbor because there's no one to sign off on it.
Yeah.
It becomes very ambiguous.
That was my thinking. So I was thinking if it's going to happen anyway, we can just be silent on it.
Yeah, and there are comments from engineering and construction services. They've recommended conditions, so I'm hoping that they would have reviewed anything that would concern them in terms of parking, circulation, or staging.
Yeah.
Perhaps we can ask Mr. DeMello to comment on how that would be protected to maybe give you some comfort that that's being addressed. He did mention that. Mr. DeMello?
Certainly, Mr. Chair. As part of the OLT decision, the parking standard was reduced, and as a result of the reduction in the parking standards, my clients need to maintain 287 parking stalls total, parking spaces total on the property at all times. Otherwise, they would require a variance for that parking. So they have prepared a construction mitigation plan that ensures that at all times there's 287, 290 parking spaces that are going to be maintained. If it came to a situation where those parking stalls weren't being maintained, that would be a zoning bylaw violation. The city could go out and provide them with a notice or an infraction. It gets maintained because it's a requirement of the zoning bylaw. That hasn't changed.
Thank you.
Okay. So just whether there's any follow-up questions or whether someone's ready to weigh in with a motion. Mr. Taylor?
Yes, Mr. Chair, this is a very reasonable application that's going to enable the construction of more much needed housing units. I move approval of the consent application, subject to Community Planning Department conditions, engineering and construction services conditions, and the standard conditions of consent.
Okay, thank you. Seconder for Mr. Taylor's motion. Ms. McCluskey, thank you. All in favor? You have unanimous approval. Thank you, Mr. DeMello. Good luck with the project. Okay, we've been at this an hour. We have probably another hour to go. Perhaps we can have a 10-minute break. I want to try to get my computer restarted, which doesn't appear to be cooperating. My city-issued computer, so I may try to put it on another device. So how about we return at 2:15?
2:15 is good, Mr. Chair. Thank you.
Okay, thank you. Okay, welcome back. Guess we'll wait for Michi and Donald. There we go. Okay, so next application is item number 26, 35 Francis Avenue, A, B, and C. This is an application for consent to sever the property into 2 undersized residential lots. And on each lot, it as divided, the existing dwelling, singular dwelling on the double lot to be demolished, and on each side of the lot, if the consent is accepted, to be redeveloped as a site of a new detached dwelling with an attached garage, each requiring, I believe, 9 variances. To the zoning bylaw, we have a June 18th planning email. They had concerns and would have discussed with the applicant. We have the engineering construction services memo. And the memo from e-planning pointed out that the site plan did not show the footprint of the adjacent buildings. And we have a letter of opposition from 37 Francis. Urban Forestry is looking for conditions 2, 3, and 5. So 5 being a refusal, and they're opposed to the consent to sever. So the speakers on this application, we have Ida Evangelista, the agent for the applicant, as well as we have the neighbors from 37 and 39 Francis on the line, subject to confirmation from Adam. To discuss to be involved with this application today.
Mr. Chair, members,
Adam?
I can confirm that both area residents are present on the call at this time.
Okay, thank you. Okay, so we'll go first to, so we do have, I'm just checking, we do not have, I don't believe we have a memo from planning other than that email. Perhaps staff can advise on that as well. And perhaps Mrs. Evangelista can confirm what they've advised. That was again back in January. This matter, it doesn't look like it's a deferral. All the next number are, but this one doesn't look like a deferral. But it looks like
Chair, if I can, there's an email from planning in the additional material.
Oh, there is? Okay, I didn't see.
It just says they have no comment.
Oh, they have no comment. Okay. Because in the January 18th, they did say they have concerns and would discuss. So Mrs. Evangelista can enlighten us about that. Thank you. Thank you, Mr. Palmer. Okay, Mrs. Evangelista, welcome.
Mr. Chair and members, Ida is present on the call and she is unmuted. It should be noted, though, she didn't sign in for a microphone check, and I'm wondering if she didn't authorize the use of her microphone properly. Ida,
okay,
you're unmuted, so go ahead. Yeah, Mr. Chair, she is unmuted still, and there's nothing. Maybe we stand this one down for a moment while Ida figures out.
You can hang up, or you can advise her to do it. Normally, she would hang up and call back and log back in and give that permission.
I will, Mr.
She's
Chair.
Listening.
Ida,
okay, so let's move on.
Log out and log back in and authorize the use of the microphone. We'll stand your item down until you're back in. Mr. Chair, I can confirm she has logged off now.
Okay, thank you, Adam. So, okay, the next application is item number 27, 69 North Drive. It's an application to construct a new detached dwelling with an attached garage. And there are a lot of variances, 15. We have material from the previous hearing. This was deferred from the October 13, 2022 hearing. So we have 15 variances. We have applicant revisions. We have an arborist report. Planning has given us a conditions of approval. Transportation was looking for a deferral and then revoked it in the additional materials. And Urban Forestry looking for condition 2. Okay, the speaker on this application is Oris Stoyanowski.
Good afternoon, Chairman Committee. My name is Oris Stoyanowski. We have our planner, Stephen, here registered as well. So I would like to pass a microphone to him, please.
Okay, so he's going to be doing the presentation. Thank you.
Thank you.
Okay, thank you. Sir? The baton's been handed to you. We'll need to know your name and address for the record, because Horace is listed as the speaker. Is the planner online, Horace?
Yes, he was speaking on one of the previous applications, so I believe he should be logged in. His name is Stephen from Design Plan.
Oh, Stephen Key? Okay.
Yes, correct.
Okay, so is he ready to go?
Mr. Chair, members, we didn't have a note of Stephen Key speaking to this file, so give me a moment while I go hunt them down.
I see.
Horace, they're required to pre-register with us. And he did not.
Did. Yeah, I believe they did pre-register.
Not for this one.
Okay, Mr. Chair, I've gone ahead and unmuted Stephen. Stephen, you're unmuted now.
Okay.
Good afternoon, Sir Chair and committee members. Again, I'm here as Stephen Chi from Design Plan Services. Just to clarify, I did register to speak for this item as well. I sent both, I registered for both applications in one email, so maybe that was missed by the committee.
Okay. Okay, well, glad you're here. So,
Thank you.
I don't know if you gave me just a short I guess gave the introduction, I don't know if you heard it, but Transportation has now revoked their request for deferral. We have a planning report which recommends a condition of approval. There's, notwithstanding the large number of variances of 15. And we have the, so why don't you just, we have the materials from the previous hearing. This was deferred October 13, 2022. So why don't you update the committee as to what's happened since then?
For sure. I'll just give a brief presentation because there's a lot of variances that we're dealing with.
Yeah.
And there is some unique condition for the site. So the application was deferred at committee on October 13, 2022, as per the request from city planning. And since then, we have consulted extensively with city planning staff and made significant revisions to the proposal, which reduced the number of variances from 21 to 15, which are currently in front of the committee today. And planning has provided a staff report dated May 11 in support of the revised application and provide detailed clarification and justification for the proposal. And we have no issue with the condition recommended by planning. We have also worked extensively with urban forestry, ravine and natural feature protection, TRCA and transportation services. All of these departments and agencies no longer have any concerns with the proposal and provide a staff report to the committee. Urban forestry recommended standard condition number 2, and we have no problem with that as well. Before going into the variances, I would like to note that although the proposal is considered a new dwelling, it will be largely building on top of the existing building foundation. The subject property is quite unique in terms of lot shape, orientation of the existing building, as well as the existing grade condition of the site, which triggered most of the variances that we are seeking today. So there are 15 variants in total, and I'll try my best to quickly go through them before the time runs out. Variance number 1 pertains to floor space index. This variance is technically in nature, in my opinion. It is triggered due to 2 main factors. The first factor is that the lot area that was used for FSI calculation excluded the area below the stable top of bank, which is almost half of the actual lot area of the property. If the calculation is based on the total area, the proposed FSI would be 0.72 times the lot area. The second factor is due to the existing grade condition of the site. The established grade is well below the finished grade of the facade of the building, and therefore basement is considered the first floor of the building and therefore included in the total gross floor area for the FSI calculation. If the floor space area for the basement is also excluded, the FSI would be 0.44 times the lot area, which would be compliant with the FSI requirement of 0.45 times. Further, the location of the established grade also triggered variance number 7, 8, 9, 10, and 13, which pertains to the building height, site main wall height, soffit height under both current and former zoning bylaw, as well as main pedestrian entrance height and variances pertaining to the platforms on the second and third stories. Variance number 2 pertains to the front yard setback. The proposed front yard setback variance pertains to the pinch point located at the garage entrance, which has been improved from the original proposal and is largely following the footprint of the existing garage. Further, due to the property is located at the bend of the road, which created a reversed pie-shaped lot and irregular front lot line, and considering the constraint of stable top of slope at the rear, the entire dwelling actually encroaches into the required front yard setback. However, with the unique orientation of the dwelling will still be in line with the setback of adjacent dwellings on both sides of the property by providing 20.11 meter setback on the east portion, which generally matches the setback of the adjacent dwelling at 21.04 meter. And smaller setback on the west portion is compatible with the setback of 3.96 meter of the dwelling to the west. Further, there is quite a bit of functional front yard located within the municipal right-of-way, and a large portion of the front yard will be restored to SOLD as well. Variance number 15, which pertains to the front porch encroachment, is also triggered by the front yard setback condition. Further, the unique lot shape and building orientation also created multiple pinch points from the building to the side lot lines, which triggered variances 3, 4, 12, and 14, which pertains to the side yard setback and roof eaves encroachment variances. Variance number 5 and 6 pertains to the setback to TRCA shoreline hazard limit or stable top of bank. TRCA has reviewed the application and confirmed that they have no concerns with the proposal in their staff report. Variance number 11 pertains to reverse slope driveway, which mainly reflects the existing condition of the site. We have worked with transportation services to address their concerns, and as noted in their updated staff report, they have no further concerns. And I believe that covers all the variances. We are of the opinion that the proposal is appropriate and the associated variances meet the 4 test under section 45(1) of the Planning Act. And we respectfully request the committee approve the application. And this concludes my presentation. Happy to answer any questions.
Thank you, Mr. Key, for your presentation. There also doesn't appear there's no neighbors appear of any concerns or being sent in letters or appearing in opposition here. So it speaks volumes as well. Any questions, members, for Mr. Key, or is someone ready for a motion? Mr. Taylor?
Yes, Mr. Chair. Yeah, I'm satisfied the variances, notwithstanding the fact that there are a large number of them, to be in keeping with the 4 tests under the Planning Act. Many of the variances, as have been pointed out by the agent and the planning department, are due to the regular situation in terms of the configuration of the lot and the top of bank issue. So it's not, as it turns out, it's not quite as overwhelming as the numbers would otherwise indicate. So I'm prepared to move approval of this application, subject to the Community Planning Department condition and Urban Forestry condition 2.
Okay, thank you, sir, for your motion. Do you have a second to Mr. Taylor's motion?
Should we be tying it to the plans?
I would be pleased if you could.
I can read that. It shall be constructed as illustrated on the architectural site plan dated April 3rd, 2023, as it relates to front yard setback.
Okay. Okay. I just generally referred to the community.
Yeah.
I referred to that condition, but I didn't read the detail of it.
Yeah, that's fine. I know what it means.
I just wanted to tie it to the. Yeah. Anyway. I'm happy to second that motion. Sorry.
Thank you. Yeah, because we also have the conditions from planning. I don't know if that's included, but thank you for setting it to what the concern is, the front yard setback as opposed to. Okay. Okay, all in favor of the motion to approve the application? All in favor, it's unanimous. You have unanimous approval. Thank you, Mr. Key. Thank you, Mr. Stoyanovsky, behind the scenes. And I see
committee members.
Thank you. So I assume we can go back now to item 26, A, B, and C, as we've had Mrs. Evangelista back on the line.
Yes, Mr. Chair. We'll try Ida again. Ida, you're unmuted. Go ahead. Hi, Ida.
Hello.
Oh, good. Yay.
Okay, I'm not going to repeat my introduction, but we have a consent to sever, 2 undersized lots, and on each of them to build a new detached dwelling with an attached garage, each with 9 variances. So I'll turn it over to you for a presentation. We'll get your presentation materials up on the screen for you.
Good afternoon, Mr. Chair, members. Ida Evangelista on behalf of the owners of 35 Francis. I did hear your comments previously. Planning did then send in a notice saying that they had no further comments. We worked quite closely with planning in perfecting the application as it is. So in this particular area, the lot we have is an anomaly. There aren't many lots in this neighborhood of this size. Majority are 25, 28-foot lots. Now, what we did with planning is we have, and what you have in front of you are the revised variances and the hearing notice. So we are asking, we do not have an overall height for this home. And planning, working with them, we did bring down the main wall height. Our main wall height, if you refer to the front elevation, you'll see that our main wall height 7 meters. But on the side elevations, we have 7.10 meters, and that's due to the one window on the other lot, 2 windows that are encroaching into the gable of the roof line. So that main wall height's taken to the top of the window. However, majority, I would say 90% of the walls are 7 meters. We have removed a variance. We have reduced our coverage. Our coverage is now 34.93 on 1 and 34.84 on lot 2. So what we have in front of you, and then I also read through, so a couple of things. So I read through Engineering Construction Services. They made a comment regarding having the pole away 1 meter away from the driveway, which we have done. And you'll see that on your site plan on lot 2, it does show that we are 1 meter away. The retaining wall is 1 meter away. So in this particular house, if you take a look at take a look at page 1, you'll see that the topography of the land from the street, it goes up to the house. So there is a tree there that we will be preserving. We've taken every step and precaution to protect that tree. Not only will this tree protected, but also all the trees in the rear yard will be protected, and which is one of the comments that the neighbor made in her letter. She wanted to know if the trees will be preserved, and yes, they will be. Now there will be a retaining wall because there is that slope in the grade. Retaining wall will be placed, so there will be no erosion on between those 2 homes. That's between 37 and 35. So in closing, and also if you refer to page 3 of my proposal of my submission, you'll see that the home that we're proposing is very characteristic to other homes in the neighborhood. That was one of the comments that planning made, and we made changes accordingly. So the application as it is in front of you has been quite perfected. Planning is there in support of what is before you today. And I am open to any questions. What we're proposing, I believe, is desirable and appropriate for the use of the subject lands. It's again, it's a form of intensification that meets the 4 tests, and it is in keeping with the OP and ZBL. It is appropriate for the neighborhood, very characteristic to the neighborhood. I'm open to any questions that you may have.
Okay, thank you, Mrs. Evangelista. Does anyone have any questions before we move on to hear from the 2 neighbors? Okay, if none, let's then hear from the first neighbor on my list, Carlo the phone at 30 Francis.
Mr. Chair, members, Carlo is asked to be on camera for when he speaks. So, Carlo, I've gone ahead and made you a panelist. You can now activate your camera by clicking the Start Video button, and I'll go ahead and unmute you.
Hello, can you hear me?
We can hear you, and soon we'll probably be able to see you too.
Oh, yeah, we can just forget about the video. Let's, I suppose if you really want. I don't want to tinker around with the video. Yeah, so the proposal, I had some issues with it. A lot of variances there, and the main one basically being the view and the privacy from my yard will be severely impacted. My house, the back wall proposes, if I understand the plans correctly, will extend approximately 25 feet past my back wall. Then there's another variance for a deck, which will extend even further, that will be elevated significantly above any sort of fence, which basically will put the deck in a position to overlook the entirety of my backyard, basically exposing all my windows, my entire property to, peering eyes, which I don't want, and I don't understand. That doesn't need to be there, don't think. Also, the side setbacks, moving it to, I can't remember what the proposed was, but again, the closer it is to the property line, the more obstruction it causes. So again, interfering with my sight line, my privacy, and my general enjoyment of the property. So I do have concerns, and there was just so many variances that, given the culmination of all of them, I feel that the sum total of the many minor variances are in fact not minor, and they do in fact negatively impact the neighbors, me being one of the neighbor. So I do not feel that it meets the sort of the four criteria on those grounds.
Mm-hmm. Okay, thank you, sir. We'll have the agent to reply to your concerns. In the meantime, does anyone have any questions for the speaker?
Yeah, just a quick question. Are you at number 33, sir?
39.
No, I'm number 39, Francis.
39. Okay, on the other side. All right. Thank you.
Yeah, and now we're going to hear from the neighbor between Mr. Buffoni and the applicant, and that's 37. So it's Heiyan Zhuang.
Good afternoon, members.
Good afternoon. Hello, you're right next door.
Yes, my name is Heiyan Zhuang. I'm the owner of 37 Francis Avenue. My house is on the north side of 35 Francis Avenue.
Okay, we have your letter of objection on the board
That's
as well.
right, yeah.
Okay, go ahead, ma'am.
First of all, I would like to say that I understand that our city needs more housing, and I'm not against building 2 houses at the 35 Francis Avenue. However, I have a number of concerns regarding the proposed variance for 35 Francis Avenue. Number one, I worry about the front yard elevated landscaping, but I heard they're gonna do a retaining wall. Maybe I don't need to worry anymore. Number two, my house is a semi-detached, and I share the driveway with 39 Francis Avenue. The driveway begins on the north side of 39 Francis Avenue and the circles behind both 39 and 37 Francis Avenue. And my garage is at rear of my property. This means that my backyard is very small. According to part 1 of the proposal, the length and height of the building will block my backyard sun from the south side of my property. During the 15 years I have here, I have enjoyed growing vegetables in my garden, which will be very badly affected by the lack of sunlight, and I will have to live with a tall wall alongside most of my backyard. My enjoyment of gardening and the sunshine is one of my greatest pleasure, and it will be great loss to lose it. So I request an amendment to variance 5 and variance 8, and that new building and the rear deck setback 1.2 meters from my lot line in order to get some west light to compensate for the loss of light from the south side. I also request that the variance 9 is amended so that the rear deck floor is no higher than 1.2 meter above the established grade to avoid more negative impact on my property. If possible, could the length of the new building be 2 meters less than the proposed plan to give my vegetable garden a chance to grow? Number 3, what is the plan to protect all the maple tree at front? I think the plan Aiden already talked about. So I think they're going to protect that one. I have lived in this house for more than 15 years and I really enjoy my rear garden. It was one of the main reasons I bought the house. I appreciate your listening and consideration. Thank you.
Thank you. Does anyone have any questions for the speaker located next door to the north? Okay. If not, we'll give it back to Mrs. Evangelista to respond to the concerns of the neighbors.
Okay, so I did reach out to the neighbor immediately next door. I wasn't aware that Carlo at number 39, 2 doors, I believe, to the north, had any concerns. So let me address Carlo's concerns, the view and the privacy. So right now, our deck, so if the deck is projected 2.45 meters off the rear main wall, it wouldn't be considered a variance. However, the reason why in this particular area, and let me add that the deck is not big enough or wide enough to even entertain on. It's a small deck. It's just basically something to come off of your main dwelling, step down and go down the stairs. And the reason why we have that variance is because they have counted from the rear wall of the home to the bottom of the stairs, and that's what they considered as the projection, and that's why we have that variance of the height of the deck. But I would like to add, we're willing to put privacy fence up if that helps in any way, but I would like to assure them that, you know, the deck is not large enough to be entertaining on. If you could have a little bistro set, that would be about it. But again, we could put in some screening. The setbacks that we have are consistent with this neighborhood. You could see from the building footprint, and even, you know, in conversations with staff, we have increased the setbacks. And typically in this area, it is about 0.60 and around that, you know, that side yard setback, enough to allow for light, air, and maintenance, which it does do that. As I mentioned, we've been very careful in designing this home. We do not have a length variance. We have come below the 17 meters. Now, this particular home, so our rear yard, and now let me address the rear yard. It's pretty hot and it's pretty sunny, and from, you know, spring to early fall, it's sun all day long. I would like to add that there are trees back there, and she does have her garage, which she mentioned. So I respectfully submit that having the homes plotted as such and below the length that is permitted, and it being an east facing rear, I don't believe, and I respectfully submit that I don't believe that it will have any impact on her garden. She does have a fairly large area. Her garden is closer to the rear of her home. It's all paved at my apologies. It's closer to the rear of the house, and beyond it's all paved. So where she has her garden, she will receive sunlight. I was quite careful, and I went, as you can see from the photos I submitted, I did go to the property and did take quite a good look around to see if anybody would be, if this would affect their yard, their view. So what we have here, and like I said, we're maintaining, I know trees is quite a concern with the area residents. We are maintaining that. We are taking special caution for the city tree at the front. We are taking special caution with, the topography of the land because it does rise. We will be putting up a retaining wall, and we've taken all measures to design two homes that is very characteristic to other homes in this neighborhood. And as I mentioned, this particular lot with a handful of others is an anomaly in this area. So I believe I have addressed the two neighbors' comments and concerns, and I'm open for any questions that the members may have.
Mrs. Evangelista, I have one little question. I don't see a length or depth variance. So your building going back is within the subject of consent, but in terms of the variances, there's no variance for the length of your building, is there?
No, Mr. Chair, there is not.
Okay. And I do see, I guess you're on the north side, so that but they will get sunlight.
So
I guess east and west, there's no there, but it is what it is. But I don't see a length or depth, so I don't see how the big effect on that. Does anyone else have any questions for Mrs. Evangelista or any of the two neighbors at this point? But after the rebuttal. Okay, and planning okay.
Is planning okay now? Because I noticed they were
in January
about the site plan, not showing the other properties.
And that was back in January, I think, and then since then they've sent another memo saying they're fine and I won't be commenting, correct?
Okay, so that was in an email, right?
Yes. Sorry, I'm not supposed to answer.
So did you change your site plan then to show the footprint of the adjacent buildings to satisfy planning in order for them not to be commenting at this point? Almost, 6 months, 5 months later.
Mr. Chair?
Yes.
If I may address Member Alderson's question. Yes, we did. That was going back in January, and since January, we did provide a site plan with the neighboring properties. As you can see, those are in the materials that we've provided you. Planning then subsequently have sent in an email to Nicole stating that they have no further comments, as we have addressed any comments that they have, and all changes that they wanted done, we obliged.
Okay, and just one final question. Would you say these properties, these houses constitute what the Long Branch community refers to as soldier homes? Would you say that these are soldier homes? Based on the height? I mean, I know there's no height variance, but there's a wall height variance, I believe, that you're asking for.
On what we're proposing, yes. On what we're proposing, yes, I do. And as I mentioned through Mr. Chair, Member Alderson, that main wall height is just strictly to the top of the window as it penetrates the gable. However, we do meet the main wall on the front and most of the sides and the back. So yes, in answer to your question, yes.
You would consider these soldier homes?
Yes.
Okay. And I don't believe there are any on the street at this point in time. You would actually be the first.
We would be the first. This is more in keeping with what they would like to see in this neighborhood. And as you can see through on Guthrie and Wineska, that is what is, that's basically the trend that it's moving towards. And that's why we had to work and we had to do a redesign based on planning's comments for that reason. And
Okay.
that's why we had to defer.
Okay, thanks for clarifying.
Okay, any other questions, or is someone ready for a motion? Mr. Taylor?
Yes, Mr. Chair. First of all, with respect to the consent application, if you look at the location map, the proposed lots are virtually identical to the existing lots running north from this lot on the east side of Francis Avenue, and identical to the lots across the street from number 40 to number 46. And they're also identical to the two lots directly behind them on, I guess it's Guthrie Avenue. So I think in terms of the configuration and lot size, frontage and depth, they're quite compatible. And I would recommend or move approval of the consent subject to engineering and construction services conditions and the standard conditions of consent. With respect to the variances, I think most of the concerns that we heard from the two neighbors to the north had to do with a decline in their enjoyment in their rear yards. But I think, Mr. Chair, as you pointed out, there are no rear yard or building length variances requested here, nor is there an overall height variance needed. So I'm satisfied the variances meet the four tests of the Planning Act. And I move approval of the variances subject to urban forestry conditions 2 and 3, which were set out in their comprehensive chart, and 1, which was set out in a freestanding memo dated May 11th. So urban forestry conditions 1, 2, and 3.
Thank you, Mr. Taylor, for that well thought out motion on this. Seconder for that motion. Mr. Palmer, thank you. All in favor? Unanimous approval. Thank you. You have your approval, Mrs. Evangelista, and thank you, the neighbors, for your participation as well. We've done 27, so we can skip over to item number 28, 74 the Kingsway. This is an application to construct a detached garage in the rear yard with 5 variances. We have material from the previous hearing. This matter was deferred from the April 27, 2023 hearing. Urban Forestry is looking for condition 2. We have 2 letters of opposition from 381 and 383 Prince Edward Drive North. And then the additional materials we received, photographs and the preservation plan and an arborist report. Okay, and the speaker, we have 3 speakers on this application. Well, actually 2, or actually 1. We have a whole team here. We have the agent Sal Creamy, as well as we have on the line the homeowner and the arborist. Oh no, sorry, the arborist is representing another property, 390 Prince Edward North. So we do have a second speaker, being the architect on behalf of an adjacent neighbor. So let's hear first from Mr. Creamy. Welcome, sir.
Mr. Chair, committee members, Committee of Adjustment staff, Sal Creamy for the file of 74 the Kingsway on behalf of the owner and the applicant.
Okay, why don't you first of all give us a small presentation, let us know again, just remind us this matter was previously deferral and what's happened since. The last meeting, I believe.
Yeah, the deferral was from the April 27th hearing, and that was for the purpose of proper notice. When the application was first filed with the committee office, a out of date survey was used with incorrect information. As such, when an updated one was obtained, the lot areas changed slightly and inevitably changed the variance numbers. All percentages being requested stayed the same. The required minimum changed. So as such, we needed proper notice, and that's why we're here today.
Okay.
And a brief background on the file. The existing garage, as you'll see by the pictures I submitted, is in a severe state of failure. Why the proposal is before you. It's leaning heavily towards what would be the side lot line, which would be to the west. It's leaning heavily towards that lot line, and then also through the wall pictures, you'll see that the wall assembly is actually failing as well, evident by the cracking, which was backed up by the engineer who had looked over the garage originally. And the trees have always been something that is a sensitive matter when looking at this project and was respected in the design for it. As you'll see on the structural details for the building plans, it's been opted to proceed with a slab on grade method, which would avoid the need to excavate and install 4-foot footings per Ontario Building Code. Further, both the owner and the neighbor have obtained arborist reports. The owner actually worked with Davies Trees, who is a respected arborist within the industry, and the City of Toronto actually holds contracts with Davies Trees as well. And that report is before you, and along with the preservation plan for the trees that are surrounding the re-erection, we'll call it, of the existing garage. Footprint of the existing garage will stay the same, as well as height. Further, in consult with community planning, there were concerns with the existing soft landscaping that is present within the rear yard of 74 the Kingsway. Through discussion, we came with an amicable solution which would introduce the installation of permeable pavers in place of the existing cement non-porous pavers, and that's shown on the updated site plan as well. So it's not, you can't change obviously soft landscaping with the use of permeable pavers, but planning was happy that we were able to better this soft landscaping situation within the rear yard. And lastly, I do want to confirm that Davies Trees will be contracted as part of the demolition and construction of this new garage, as it is a condition of both Davies Trees report and the arborist report of the neighbor. Further, the recommendations within the neighbor's arborist report are sound, and I myself do agree with them as well, that there can be the modification of the building. This would have to be something consulted with the engineer, but it does propose to maintain a portion of the existing slab on grade around the protection zone of tree number 2, which is the blue spruce closest to the garage. And thinking about it logically, that is a method that can be used. And if not, all parties can be present during that day to come up with an amicable solution. But again, the construction manner proposed for the garage is the best that will ensure the longevity of not only tree 2, but all trees surrounding the reconstruction of this garage.
Okay, thank you. Any questions for Mr. Creamy before we hear from the neighbors? Okay, yeah, I see that. I guess 390 is the property. I'm looking at the location map sort of directly behind, where in the area where the garage is being rebuilt, and the abutting property most directly affected. And so I believe their arborist is representing them. This is their concerns are with the trees. So we also have urban forestry, I guess, is requested condition 2 or condition 1 and 2. I can't tell here. So okay, let's hear from the arborist for the neighbor, Peter Kuntz.
Good afternoon, Mr. Chair and committee members. My name is Peter. First off, can you hear me?
Yes, loud and clear.
Great. Good job, Sal Creamy. I've worked with Sal Creamy in the past. That's just an aside. My name is Peter Kuntz. I am the owner of Kuntz Forestry Consulting. We are a urban forest management consulting firm. We have standing contracts with the City of Toronto, Toronto Water, Waterfront Toronto, Build Toronto, and so forth. We have been retained by the owners at 390 Prince Edward Drive, who, as you mentioned, Mr. Chair, reside behind 74 the Kingsway. I was retained to do preservation planning for tree 2 per the Davy Tree report. That's the tree number of the blue spruce that Sal Creamy has referred to. This tree resides 1.15 meters away from the building. It's hard to tell if the building is exactly on the property line, but if it is not, it is very close. So the current structure resides, basically just over 3 feet away from the base of this tree. That's not a great situation for the building or the tree. So we have concerns. We had concerns until Sal mentioned today that he has reviewed our report by the sounds of it and is willing to adopt the mitigation measures outlined in our report. I'm happy to go through those with you. Maybe they're not pertinent to this session if they're going to be adopted. I have been involved with TLAB, LPAT, OLT, OMB on many, many files and have worked with other arborists to come up with a list of mitigation measures that are suitable to both parties. And so if the proponents of 74, the Kingsway, is willing to adopt our list of mitigation measures, then I think this is a moot point, and we're very pleased about that.
Okay, so
I'm happy to answer any questions or present any details.
thank you, sir. So the question is to staff, I guess we don't within our purview or to make, they're going to work this out with urban forestry. I see was just looking for a condition, but they're going to be able to work this out. We don't need to impose any conditions or are not able to impose any conditions in terms of these mitigation efforts. We have to just assume the parties are going to work together in concert and cooperate. I assume both parties want to maintain this tree, both the neighbor on whose property it resides as well as the neighbor who's going to be looking out at it and getting the enjoyment of this blue spruce.
Mr. Chair, may I add that my client expressed to me that we have an opportunity here to push the building back. Currently, as I mentioned, it's not great for the building or the tree, and especially the new building. If you're this tree is going to continue to grow. It's a 31 centimeter blue spruce. It's in very good condition. And this is an opportunity to have the garage put back, set back, a foot, 2 feet, whatever would be helpful to preserve roots within the minimum tree preservation.
Okay, and this is since we don't have the benefit of video, this is Peter now speaking, correct?
Correct. Sorry.
Okay.
Sure. Yes.
So, and is that like the cities? We're not going to start redesigning the house here. So, again, I'm confused now. If we're talking in a potential redesign, as well, I haven't read your scope of that he's now said he's prepared to accept, or his client is. Does that involve moving the garage back?
Mr. Cream, that would be a question for Sal Creamy.
Yeah, so I just want to make sure is whatever parties are saying, yeah, we're going to work together, we're going to work this out. We all want to save the tree. If that involves moving some of the build form,
right?
Are we not premature? Barb, can you weigh in on both matters? What I raised, we're not being asked to start imposing a condition as part of any approval. And secondly, what's before us is what's before us. It doesn't involve starting to move a proposed garage somewhere else on the site or pushing it back.
No, this application was deferred, so any opportunity to make revisions would have already happened. If they still want to make revisions, then it can't be done on the floor. It's too late.
Yeah, we're not. So I don't know what Mr. Creamy's expectation is, or what Peter Kunz on behalf of the next door neighbor, what we're going to accomplish here. But we're looking at rebuilding a garage here. That's what this whole application is about. And if it involves you potentially saying, and the agent potentially agreeing that you're going to move this proposed garage, then I think we're going to have to wait, no? Because you're going to have the variances may change. You start relocating where the garage is going to be and push it back on the site. Comments, anyone? Or can the mitigation efforts that the neighbor's landscape architect and apparently the agent is agreeing to, is that doable without affecting the variances that you're seeking to have them approved here today?
Chair, really the only variance that we're looking at there has to do with variance 4 for the eaves.
Okay, right.
But 0.
But if he moves the garage, doesn't someone have to get a plans examiner to see if there's any other variances triggered?
Yeah, no, that's true.
I don't know how far they plan on talking about moving it, like a foot, a meter, an inch. I don't know.
Yeah,
So
Mr. Chair.
get the applicant to comment on that. What we're talking about agreeing here for this to save this tree, does it involve moving the proposed rebuilt garage? Otherwise, you may have to come back and pay another fee and have another application.
Through you, Mr. Chair. No, I've listened to the discussion so far. I didn't agree, nor did the owner agree to move the garage. It was a recommendation that came out of Mr. Kuhn's report. Again, I'm going to reiterate the design methods that have been used to rebuild this garage are as of such that prevent the least impact to the root structure. Furthermore, both Davy trees and Kuhn's can be in presence during the deconstruction of it, which the owner will be in agreement with, so that the arborist can be present during the deconstruction of it. Moving this garage is going to now move this further into the rear yard, reducing soft landscaping percentages. Further, as you can see through the pictures, some, I want to call them expensive upgrades have already been made to the rear yard. Now, unless the owner of 390 has had discussions with 74 Niagara and is possibly going to provide financial incentives for them to do that. That hasn't been the case thus far. And nonetheless, moving the garage is still going to have this garage in close proximity to the tree, which is going to continue to grow well past the expected life cycle of the garage. And the roots will inevitably always be an issue. And this construction manner has that in mind as well. So moving it a foot or 2 feet isn't going to change anything.
Right, but may cause new variances. So that's the only reason I brought it up, sir, was that I heard the neighbor's architect or arborist state that you've agreed to adopt, and I haven't read that, your methodology. And if that method, I'm just pointing out, if that methodology and asking Peter now, if that methodology requires the building to be moved, then I clarified that the homeowners and his agent are not agreeing to that. So I trust that there's some other methodology. And Sal is saying it's the best thing for the tree anyway. So I just want to make sure that there's no agreement that the parties think they have that they're in fact having, because that's not what I heard here today. It involves moving the building. So, Mr. Kuntz, your comment on that?
One moment, Mr. Chair. All right, Peter, go ahead.
Yeah, thank you. Mr. Chair, this is Peter Kuntz. I structured my list of mitigation measures so that I started with I just presented the opportunity to move the building. If that's not an option, that's fine. I then structured my mitigation measures to account for keeping the building in the same place. And that was to preserve the existing slab for the extent of where it intersects with the minimum tree preservation of zone 2. If they can incorporate the existing cement slab, because they intend to build a new slab on grade, engineering wise, I'm pretty sure that can be done, and that's the best scenario for tree 2, and then we are good to go. The only other mitigation measure that the proponent may not wish to adopt is they had mentioned to my client at 390 that they want to put eaves troughs on. Currently, the water is conveyed off the existing structure into the root zone of the tree 2. So we'd like to maintain the hydrology for that tree. And if we can, so we're fine with them putting on an eaves trough as long as we convey the water into a weeping pile that would then run into the root zone of tree 2. That is articulated in my list of mitigation measures.
Okay. All I was interested in making sure that there wasn't the only methodology that he said he's accepting, and you think that he's accepting, involves a relocation of the building, which is not going to happen because A, he's not willing to do it, and B, if he did it, there'd be new variances. In that case, we shouldn't be proceeding today. So that's what we've clarified here. Okay, so just wanted to make sure everyone was on the same page. Okay, members, any questions, follow up for either party? Or is someone ready for a motion?
Sorry, just a question for Mr. Crimi. Regarding the permeable pavers and soft landscaping, that's depicted, I believe, on site plan 00A0. Is that correct?
Through you, Mr. Chair. Correct, Mr. Palmer.
All right, thank you.
Okay, any other questions, or is someone ready for a motion?
Yeah, I'm ready for a motion. I'm going to move for approval. The variances requested are minor in nature and meet the four tests in the Planning Act. I'm going to tie that, especially on the soft landscaping, and to add the permeable pavers per site plan A01, and then per forestry condition number 2.
Okay, thank you. We have a seconder for Mr. Palmer's motion.
Sorry, can you clarify what your first condition was? I didn't understand.
Okay, so the variance for the rear yard soft landscaping is tied to site plan A01 with the addition of the permeable pavers that are in A01 as well. Because the permeable pavers, I understand, are not considered soft landscaping, part of the hard landscaping.
Yes.
They'll mitigate as opposed to putting in asphalt or concrete or something like that, because you get the water seepage into the ground.
Okay, thank you.
Thank you. So we were just looking for a seconder for Mr. Palmer's motion. Mr. Taylor, thank you. All in favor? You have unanimous approval. Thank you. And thank you, Mr. Kuntz. Thank you, Mr. Crimi. Okay, our next application is item number 29. This matter was deferred from April 13th, 2023 hearing. It's 20 KENORA CRESCENT. It's an application to construct a 2-story rear addition and a new front porch. There are 3 variances. We have materials from the previous hearing, I guess twice, in the additional materials. We have an opposition letter from 22, and there's some confusion over where he lives. He lives at 15, but he owes 22, so we'll hear about that. Then we have support from 22 and 26. So again, we'll hear about that, why there's this discrepancy from 22. We have the minutes of the previous hearing. We have supporting material, presentation materials. We have a planning condition of approval. They want it to be constructed as illustrated on the architectural plans with respect to the building length. And we have support for number 10. Yeah, apparently it looks like they reduced the length and now planning is in support. Okay. Speaker on this application is Bruno Lopez.
Mr. Chair, before we go to Bruno, I want to bring to your attention that the area resident is not present on the call at this time.
Okay, thank you. Okay, so we only have Mr. Lopez on the line. Mr. Lopez, welcome.
For 9 St. Clair Avenue West.
Yeah, you got cut off there a little bit. We heard the address and not the name.
Sorry, my name is Bruno Lopez from MXL Engineering and Associates, located at 1649 St. Clair Avenue West.
Okay, thank you. Okay, why don't you give us a little brief history, background of what's happened. You were here April 13th and had to defer, and now you're back, and a little bit about the discussion as to what's proposed here. It's just a 2-story addition and a front porch.
Yes, absolutely. So this is a very simple project. Actually, it looks more than it is. Just to give you a bit of briefing, this building was actually in the very recent past was a fire hall. So this house has no basement. This is actually something to have in huge consideration, because having no basement, you reduce your usable area. As we know, new houses with basements, they increase actually a lot of the user space. In this case, what happened was that when we initially started drawings, we were using an old planner survey. And because committee requirement of having new survey done, we've done a new survey, and that's why the numbers slightly changed. And that's the reason why we differ from previous committee, and we are here today. So we have a few minor variances. One is the side yard setback. So we are 6 centimeters short, which is pretty much almost nothing. And to bring to your attention, actually the lot is on a pie shape, and the house is actually getting away from the property line. So it's something very, very minor. The other two, in terms of length and building depth, it's not uncommon for this area. So I did a little bit of research, and I don't know if staff, this is my mistake. I should actually provide a plan on this scenario. We got a couple houses, actually, at least 6 or 7 houses on the vicinity on Blackthorn Avenue, especially number 351. Actually, I was very, very surprised because the lot number, or actually address 351 Blackthorn Avenue, I did a little bit of measurement, and actually this building is actually 32 meters. And it's a residential house that is actually recently constructed. So I was appalled. So number 378 per se, we have about 24 meters length. 351 Blackthorn is about the 32 meters. 365 Blackthorn is 23 meters. 353 Blackthorn is 23 meters. So again, this is just to give you a little bit of an idea that on this vicinity, within, let's say, 2-minute walking distance, we have a few examples of houses actually bigger than the one that we are proposing. So in a nutshell, again, we are trying to make this a little bit better livable space. And because, again, we have no basement, we'll try to move in, and I left on purpose on the design. The kitchen is now towards the front of the house, and we are moving to the rear of the house. So we are trying to gain some space to actually have, let's call it, a decent living room. And again, it's very unfortunately that we have to hit these variances, but that's the reason we are here today.
Okay. Thank you. Is it this application? Yeah, there's some sort of back and forth email or texting thread with different colors coded between some discussion with the neighbor. So we don't have the neighbor here to speak, but we have this discussion about something back and forth of I don't know if it's all construction related, and there's all kinds of things going on, but is that at all relevant to I don't know if any?
I don't think it's relevant, but following one of the committee members that was actually present last time, Laura, I went through and with the homeowner, and we tried to put something together and respond in that letter. So in a nutshell, what happened, there was an existing old retaining wall on property line that was very old and just literally with a bunch of trees that grow on it. It was rotten apart. It was just a nest for rats and mice and whatsoever. So this homeowner just started to make a good shape of, let's say, of the lot, and then bring it to where he would like it to have what it's getting today. And they agreed to do the wall at my client's cost. And he built the wall, he built the fence. I believe somehow there was a disagreement, and that's when things went a bit sour. But however, this construction was not permitted because was not require a permit. There is actually one order, and the order was because, in fact, the homeowner, he would like to do sort of a feature wall in behind the house, and that wall was done with proper footings. So because that is more than 1.2 meters, he decided to do a couple columns. That's why it triggered this order. But the order has nothing to do with what we are proposing today.
Okay. Anyway, okay, you see we have a lot of support here. 22, you have a form letters 26, KENORA.
16, 18, yes, all the neighbors are in support. And in fact, just to bring to your attention and the committee attention, actually, the person that is renting at 22 KENORA, he actually signed a letter of support.
Okay. That's what I was asking. You had opposition and you had support, but he lives at 15, not 22, but we had a little. Okay, so now I understand. Okay, members, any questions for Mr. Lopez, or is someone ready for a motion? And we have urban forestry condition 2, and I believe we have, is there a planning condition? I think, no. No planning condition. Just urban forestry. Okay. So members, any further questions? And if not, are we ready for a motion? I can't see visual, so if you can please call out. If you're right. There we go. Getting everyone back. Yeah, Mishi? I thought Mishi McCloskey had her hand.
Mishi, go ahead.
Yeah, thanks, Don. Yeah, I'm ready to approve the application. Believe it meets the 4 tests, subject to urban forestry condition number 2.
Thank you. Seconder for Ms. McCloskey's motion. Ms. Alderson, sorry, thank you. All in favor? Another unanimous approval. Thank you, Mr. Lopez. Have a good afternoon.
Thank you. Bye-bye.
Too many unanimous approvals today.
Yeah, well, it's nice to see.
I think we're going to shake it up in the next application.
Yeah, I think though what's nice is that we've seen more new builds, which there's been, I guess, due to the government seeking to cool down the economy. They succeeded. We were having like 40, we were down to like 20, and less new builds. So new builds, I guess, are good for, especially when they're multiple new builds, are good for housing in the city. Okay, so I guess we can move on to our last application for the afternoon. Item number 30. It's 12 Goswell Road. It's an application to construct a new detached dwelling with an attached garage. This matter was deferred from March 23rd, 2023 hearing. There are 4 variances, and we have supporting materials. We have planning looking for a condition of approval, and we have support from number 10. The condition relates to the building length, and I guess that's all we have. The urban forestry looking for conditions 2 and 3, and the speaker is Lindsay Bruce.
Can I just draw attention to the previous materials? There are, I believe, 4 letters, which I'm sure still stand of objection. So I would just turn your attention to those 4 letters.
Yeah, the reason for the deferral and anything's changed, so the things haven't changed, and obviously what's in the materials in the previous hearing are not are still relevant, including those letter of objections that are the last things in our package, and so we can hear from that from the applicant. I don't know if the minutes show that there are other people here scheduled to speak when it was up here in March, and now it's too nice a day, so they're not here. Pulling up the minutes. Doesn't look. Yes, we did have correspondence from 16, 5, 3, and 1, and that's it. They weren't here in person, but we did have the 4 letters. So thank you, Ms. Alderson, for pointing that out. They are certainly relevant. So let's hear from Lindsay Bruce.
Good afternoon, members. This is Joel Tanner on behalf of Simple Design Studio, and I have Lindsay Bruce beside me over here at 15 Colburn Street in Hamilton. So we did defer the last application. We did reach out to the neighbors. We very much addressed, I think the larger, more substantial concerns came through the neighbor at 16 Goswell. Nicole was mainly concerned with the items pertaining to construction methodology. And so there are some road repairs that are needed on Goswell. They don't have curbs, so they're worried about damage to property during construction. And so it was very much driven off of, what's the process? So we had some in-depth discussions, provided some additional information to Nicole. Also provided contact information for Nicole to the owners. So if there is any issues during construction, they can communicate directly with the homeowners and the builder. We do feel like we've come up with a piece of architecture that does blend in with the streetscape quite nicely. As much as it is a new build, we are trying to keep the overall building form that is existing on Goswell today. That is what was driving the really steep pitch roof line in order to pull down the overall streetscape of this new build. So looking at the presentation here, we can go through it quickly. We're on page 1 presentation. If we can skip to the next slide. So this is the existing 2-story dwelling that exists there today. For the next slide. this is the proposed. So again, it's a two-story, single-family dwelling, two-car attached garage, glazing on the left-hand side for office and for entry vestibule. Next slide, please. So variance number 1 is related to side yard setback. The minimum aggregate side yards is 3 meters. We're sitting at, or sorry, 3.1 is required. We're sitting at 3.0. So we have a slight discrepancy of 0.1 meters that we are requesting here on our side yard aggregate variance. Next slide, please. Variances number 2 and 3 are related to building length as well as building depth. We had some great correspondence with the neighbors at 10 Goswell, and we did pull back the above grade building length to 18 meters. So that was a request from not just the planning department at the city, but also from the neighbors at number 10. So we were very happy to do that in order to keep everybody happy with the overall proposal. I'd like to note that the below grade building depth, we are still over. And so that is why these variances exist. But again, the above grade are in keeping, and the planners are very much aware of this, as are the neighbors at 10, which are the most affected neighbor on the streetscape when it comes to this requested variance. Next slide, please. Final variances just regarding the front entry steps, and so obviously trying to create a bit of a grander feel. So the permitted max encroachment is 2 meters on the width, and we're seeking 2.4. Again, we feel that it is quite minor in nature. Very happy to answer any questions regarding our proposal here today. But again, I just want to reinforce that after the initial deferral, we did reach out to the neighbors and had some discussions to ensure that we are putting forth a proposal here that makes sense for the community and is in keeping with the neighborhood development. Thanks so much, committee.
Thank you. So you reduced the length, it looks like, in response to the neighbors. I saw there's 10 Goswell's approval letter, I think, in the additional materials.
That is correct. Yeah. So that was a post-case discussion between the neighbors to come up with that resolution, right, along with planning seeking that as well.
That was, the length was reduced to 18 as per, looks like it was only initialed by one party, but by Mr. Rogers, but that has been done, I take it. Okay.
Correct. Yeah, on the above grade building envelope. That's correct. Yes.
Exactly. The above grade. Okay. Thank you, Mr. Tanner. Does anyone have any questions for Mr. Tanner, or is someone ready to weigh in with the motion?
I just have a comment. This is a very special street. This is a very unusual street in Islington Village. It's got tons of heritage stone homes on it. I think the only person that's actually signed that petition of support was someone in a house directly beside it that is a more contemporary build. Other than that, these houses are all beautiful Humber stone homes. And having gone on to actually look at the interior of this home, it's also in amazing condition. There's nothing wrong with this house. So I'm frankly surprised that community planning hasn't written something about it not being in keeping with the physical characteristics of the neighborhood, because it really is not. It is jarring, to say the least, that this is being allowed to be built. So I will not be supporting it. I just wanted to let everyone know in advance. If you take a look at the street view, you'll see that this is one of many homes along that street that are beautiful Humber stone homes. And I am reluctant to, regardless of how community planning feels about it, I'm reluctant to move for approval, and I will be making a motion for refusal.
Thank you. You know, when we were showing, when he was going through his presentation, he showed the existing house, I was saying to myself, that's a nice looking house.
It's even nice inside, and it was featured in Canadian House and Home magazine. I mean, it is a stunning piece of architecture.
My question is whether under the Planning Act and what our role is in terms of major design police, etc. The same thing happened in Forest Hill with all of the magnificent architectural, I can't remember the name of the architect, from the 20s and 30s. And maybe 100 years, we're going to be sitting here trying to protect Richard Wengel homes.
Yeah, exactly. I think it falls under the desirability aspect of, I mean, we are sometimes given that leeway to say this is not a desirable house for this neighborhood. And also it is not in keeping with the physical character of this particular street. So
that's where you slide in under the
so I can slide in under that for, as far as I'm concerned, it's not a desirable home.
I think it's all you'd like to make that motion to refuse the application, and we'll see what that takes us. Okay, so motion to refuse the applications for the reasons stated. Seconder for that motion. Okay, so it looks like that motion fails, notwithstanding some or all of us may feel similarly to you, but the issue is what our role is here, similarly to some other applications. Given this, you know, the application was refused for landlord tenant. The landlord sounded like a bad actor in terms of his tenants, but we look at planning concerns. He was going to add turn the main floor locker room to an apartment, a badly needed apartment, and we wrap them on the hands by refusing it for not planning reasons. So my question is, this one, it seems you're sticking it under the planning, but it looks like the other members, notwithstanding they may agree with you, as I do, I can't support your motion. I don't get the seconded anyway. So no one's seconding that motion. So let's have another motion. Mr. Taylor?
Yeah, first of all, Laura, I very much respect your view on this. And I have similar thoughts many times over many hearings about, you know, altering perfectly good buildings. But anyway, at the end of the day, I kind of fall back on our primary responsibility to assess these from a planning perspective. And I look at these variances and I see them as, I'm quite comfortable that they're minor in nature and meet the 4 tests. So I'm going to move approval subject to the planning department condition and urban forestry conditions 2 and 3.
Thank you, Mr. Taylor. Do I have a seconder for that? Mr. Palmer, all in favor? Okay, the motion carries 4-1. The application is approved. And I think the name of that architect from Forest Hill is in fact Taylor. I could be wrong, but
I think you may be right.
Okay. No relation perhaps, but
not me.
Yeah. You know, people have property rights, and I guess the issue is we're not, you know, certain areas of Hyannis border Massachusetts, so they have like certain protective bylaws, but
I'm frankly surprised this wasn't protected under heritage conservation.
Okay, so the motion, let's get rid of the applicant. Your application has been approved 4-1, and have a wonderful day. And now we need a motion to adjourn.
I'd be happy to make that motion.
Okay, thank you. Seconded by Ms. McCluskey. All in favor? Then we're adjourned as of 3:34 p.m. Thank you, everyone, especially to our devoted staff, the hardworking staff, for making sure everything runs smoothly behind the scenes.